5 seconds to go. Start. Once the order of dismissal dated 3rd January 2003 had been passed, the High Court should not have directed continuation and conclusion of the departmental proceedings pursuant to another charge sheet relating to embezzlement of funds, irregular payments, missing vouchers, etc. On the said aspect, the learned division bench and the single judge in the orders under challenge have rightly observed that there cannot be two orders of dismissal, yet have erroneously commented upon the inquiry report and the second order of dismissal dated 25th October 2013. This second order of dismissal should have been set aside on the limited ground and reason that there cannot be two orders of dismissal, leaving it open to the appellant to take steps and recommence proceedings in the charge sheet relating to embezzlement of funds, irregular payments, and missing vouchers, etc., should the first order of dismissal dated 3rd January 2003 be set aside. In other words, departmental proceedings void the charge sheet relating to embezzlement, irregular payments, and missing vouchers, etc., should, for the present, be kept in abeyance. Reference in this regard can be made to the judgment of the court in State of UP versus Vijay Kumar Agarwal and another 2016 3 SCC 197, wherein it has been held that the employee who has already been dismissed from service cannot be imposed any other penalty on the conclusion of inquiry pertaining to the charge sheet dated 6 July 1988. Therefore, at this stage, no purpose is going to be served to continue with the inquiry into the said charge sheet. At the same time, it is also to be borne in mind that Respondent 1 has challenged dismissal order and the matter is pending before the tribunal. In case the said dismissal is set aside by the tribunal and or the High Court, this court and Respondent 1 is reinstated in service. As a result thereof, the relationship of employer-employee between the parties shall also stand restored. In that eventuality, it would be permissible for the appellant to proceed with the inquiry relating to charge sheet dated 6 July 1988. Accordingly, the present appeal is partly allowed, whereby we agree that the second order of dismissal dated 25th October 2013 could not have been passed, and accordingly we would set aside all observations and findings recorded by the division bench and single judge with regard to the inquiry report dated 28th May 2012, with the direction that further proceedings pursuant to the said inquiry report would be kept in abeyance and can be recommenced in case the first dismissal order dated 3rd January 2003 is set aside and quashed. In case of recommencement, it will be open to the first respondent to raise objections to the inquiry report before the disciplinary authority, who would consider the said objections. It would be equally open to the disciplinary authority, who would consider the said objections. It would be equally open to the disciplinary authority to rectify and correct mistakes or lapses, if any, and proceed in accordance with law. We have not made any observation on the merits of the inquiry report or the procedure which has to be followed. Stop.